All right, Thursday, Judge Alvin Hellerstein looked at Trump's legal team, looked at their motion, looked back at them, and said two words: no, denied, $83.3 million. That's what's on the line. The motion they filed tried to reopen something the court already decided. Same arguments. Different wrapping paper. Hellerstein wasn't having it. According to court documents filed Thursday in the Southern District of New York, the judge called it what it was: a second bite at the apple. And federal courts don't work that way. I've been going through this 47-page filing. The judge's language is surgical and brutal. And here's what I found. Quick context. Judge Alvin Hellerstein, senior United States District Judge, Southern District of New York, been on the bench since 1998, appointed by Clinton, handled 9/11 litigation, handled Guantanamo cases, not new to this. The issue, Trump's legal team tried to relitigate something that was already decided. Specifically, they filed a motion attempting to revisit the basis for damages in the Jean Carroll defamation case. The jury already ruled, the appeals court already affirmed, and now they wanted another shot. Timeline, fast version. Months ago, jury awards Carroll $83.3 million in damages. Weeks ago, Second Circuit affirms key portions of the verdict. Last Monday, Trump's attorneys file new motion claiming newly discovered procedural grounds. Thursday, Hellerstein shuts it down. Hard, that's the setup. Now the documents. What makes this different from a normal denial? The language. Hellerstein didn't just say no. He explained exactly why what they tried doesn't work. Page after page of legal doctrine explaining that federal courts have rules and you don't get to ignore them because you don't like the outcome. Okay, the evidence. First document filed Thursday afternoon. I pulled page 23. It says, quoting here, "The doctrine of issue preclusion bars relitigation of matters already determined by a court of competent jurisdiction. This motion seeks precisely what the law forbids." That's not my take. That's the filing. What it means, once a court decides something, you can't come back with the same argument wearing a different hat. Done means done. But here's what got me. Page 31, different section. The judge addresses the specific newly discovered grounds Trump's team claimed. Their argument, a procedural technicality in how jury instructions were delivered, gave them fresh standing to challenge. Hellerstein's response: this argument was available at trial. It was available on appeal. Counsel chose not to raise it. The failure to previously assert an argument does not transform it into a newly discovered basis for relief. Read that again. They had this argument the whole time, didn't use it. Now they want credit for discovering something that was sitting in their pocket. Put those together. Yeah, the judge is saying they're playing games. I went through this 3 times. Patterns clear. Motion filed February 3rd, claimed new legal basis. Hellerstein traces that new basis to trial record from months ago. Trump's own attorneys referenced similar arguments in earlier filings. Court concludes not new, just repackaged. All documented now, what nobody's covering. Page 38, footnote 14, the judge references 11 prior instances where courts in this circuit rejected similar second bite attempts, 11, and he notes that in 3 of those cases, sanctions were considered. Sanctions, he didn't impose them here, but he cited cases where they happened for the same behavior. That's a warning shot. Here's the other thing buried in the filing. The motion Trump's team filed wasn't just about the Carroll case in isolation. Page 41 reveals they tried to connect it to broader pattern of judicial bias arguments, suggesting Hellerstein himself should have recused. The judge addressed that too. The suggestion that this court's adherence to established precedent constitutes bias, mistakes, disagreement for discrimination. The law does not bend to preferred outcomes. 17 words, complete dismantling. Fallout from Thursday's ruling, the $83.3 million judgment, stands without additional challenges on this basis. Trump's legal team burned one of their remaining procedural options. The language in this denial makes future similar attempts harder. Within 72 hours, legal analysts started pointing out what this means for the broader strategy. We'll get to that. But first, page 44. The judge notes that Carroll's legal team filed a response opposing the motion. In it, they documented that this was the fourth attempt to revisit issues the court already decided. Fourth, different motions, different claim bases, same underlying ask, undo what the jury did. Hellerstein quoted their brief. At some point, finality must mean something. Then added his own, that point has arrived. That's just the first layer of this filing. The response from Trump's team makes it messier. The expert reactions are interesting. If this breakdown's useful, subscribe. I cover these legal developments when the documents drop. More coming on this one. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team says this motion wasn't about relitigating. It was about correcting what they call a fundamental procedural error that affected due process. And honestly, some of their argument holds up, at least structurally. Their argument, first, they claim the jury instruction issue they raised wasn't actually available in the same form during trial. They point to a Second Circuit footnote from the appeal that they argue opened a new analytical door. The footnote discussed standards for defamation damages. Their position. That footnote changed the legal landscape enough to constitute new grounds. Second, they argue Hellerstein is conflating arguments we could have made with arguments the law allowed us to make. There's a difference. Sometimes procedural posture prevents certain challenges until later stages. Alina Habba, one of Trump's attorneys, put it this way. We're not asking for a do-over. We're asking the court to address an error it created. Don't agree with all of it, but that's not nothing. What they've got, the Second Circuit footnote does exist and does discuss damages standards. Courts have occasionally allowed post-appeal procedural motions when circumstances genuinely changed. The timing of their motion shortly after the appellate footnote suggests at least an attempt at strategic coherence rather than pure delay. Even legal commentators who generally oppose Trump's litigation tactics admit this motion wasn't frivolous in the technical sense. Jonathan Turley, George Washington University law professor, noted the motion raises colorable arguments. Whether those arguments prevail is different from whether they should be heard. Look, I'm not here to tell you who's right. Carroll's interpretation, the evidence supports it. This looks like a team that lost, appealed, lost again, and now wants a fourth, fifth, sixth chance. Trump's interpretation, there's evidence there too. Courts do sometimes reconsider things. New legal developments do occasionally reopen closed questions. And Hellerstein has ruled against Trump before, which doesn't mean bias, but they'll argue it suggests a pattern. Both perspectives exist. That's what makes this legally complicated. The practical reality, Hellerstein didn't buy it. He saw what they were doing, and he named it clearly. But here's what Trump's team will say next. And they have a point about the yes, they can appeal this denial. Hellerstein's ruling isn't the final word. Like the Second Circuit could see the footnote argument differently. But unlikely, yes. Possible, also yes. Courts are weird. Precedent matters until it doesn't. And a sufficiently creative legal theory sometimes breaks through on the fifth try. I don't think that's happening here. The language in Hellerstein's denial is too specific, too anchored in established doctrine. But I'd be lying if I told you appeals courts never surprise people. What I can tell you, what the documents show, and they show Hellerstein looked at the motion, traced every argument back to things that were already decided and concluded this was procedural recycling. That's the record. Let's talk about how we got here. This didn't come out of nowhere. Backstory, quick. About 2 years ago, E. Jean Carroll sues Trump for defamation, claims he called her a liar after she accused him of sexual assault. Months after that trial, jury finds for Carroll, awards damages. Then Trump's team files first post-trial motion, denied, appeals. Second Circuit affirms core findings. Someone even said on record, back when the verdict came in, this verdict is absolutely wrong and we will be appealing. That was Trump at the courthouse steps. What happened? Exactly what he said. Appeal after appeal, motion after motion, pattern, challenge the verdict, challenge the damages, challenge the judge's rulings, challenge the jury instructions, claim new grounds when old grounds fail. Every time. Courts said no. But each filing bought time, each appeal delayed enforcement, each motion extended the story. That's the context for Thursday's ruling. Hellerstein isn't just ruling on one motion, he's ruling on a strategy of a legal pattern that's now stretched across months of filings. The no two bites language wasn't casual. It was chosen because what Trump's team keeps doing is asking for more bites. Different flavors, different presentations, same apple. And this judge, after watching it happen repeatedly, finally put it in writing in terms that make future attempts harder. Not impossible. That courts don't usually say impossible, but harder. That's what Thursday established. Following the pattern here, good. Because what happened next, the immediate response from Trump's team tells you everything about where this goes. Like this, if the breakdown makes sense so far, helps the video reach more people tracking this case. Thursday, 3:47 p.m. Eastern. Here's what happened. Hellerstein's clerk filed the denial. 47 pages, standard electronic filing through Pacer. Within minutes, both legal teams had it. The motion for reconsideration is denied in its entirety. Courtroom wasn't in session. This was paperwork, not drama, but the effect landed the same. What followed? Carroll's legal team issued statement within 2 hours, calling it decisive. Trump spokesperson posted response calling ruling expected from this venue. Legal Twitter exploded with takes, most focused on the 2 bites language. 4 hours, that fast, now, what everyone missed. While people focused on the denial itself, the headline, something else happened. Page 46 of the ruling, second to last page. Hellerstein addressed future filings. He wrote that any subsequent motions raising substantially similar arguments under different procedural labels would be subject to summary denial without further briefing. Then added this: the court will not serve as a venue for indefinite procedural cycling. Procedural cycling, that's the phrase. He's not just denying this motion, he's preemptively limiting the next one. Federal judges don't usually do that. They rule on what's in front of them. Looking ahead, warning about future filings before they happen. That's notable. Roberta Kaplan, Carroll's lead attorney, responded publicly, "The court has made clear that this case is over. We look forward to collection." Collection. That word matters because while motions fly, the $83.3 million judgment remains technically enforceable. The question has always been, when does talking stop and paying start? Hellerstein's ruling edges that question closer to answered. Now, Trump's team signaled within hours they're reviewing appellate options for this denial. That's standard. You always review options after losing, but the language in this ruling makes the appeal harder. Hellerstein built his denial on decades of precedent. 8 different circuit court cases cited. Supreme Court doctrine referenced twice. This is where it gets interesting. Don't go anywhere. What the experts are saying about this ruling, and specifically about Hellerstein's future filings language, changes how you should understand what comes next? Drop your prediction in the comments. Do they appeal this specific denial? Then keep watching. What are experts saying? Former federal prosecutor in the Southern District, 22 years experience. When a judge writes that future similar motions face summary denial, he's telling you he's done. That language doesn't appear in routine denials. Plain English, Hellerstein isn't just ruling. He's closing a door, and other than the drum. So, constitutional law professor at NYU, the two bites doctrine exists precisely for situations like this. You get your trial, you get your appeal, you don't get infinite procedural rehearings. Key there. The doctrine isn't new or controversial. It's standard. What's notable is how explicitly Hellerstein applied it. Here's what's interesting. Even Alan Dershowitz, who's defended Trump on other matters, admits hazy motion was a long shot. And courts rarely grant reconsideration on these grounds. When commentators on different sides agree something was unlikely to work, pay attention. Consensus among legal professionals. The motion was technically proper, not sanctionable, but strategically weak. Hellerstein's denial was expected by most practitioners. The language foreclosing future similar motions is the real news. That's where professionals land. A civil litigation partner at a major firm focuses on appellate work. Put it this way, you can appeal a denial of reconsideration, but the standard is brutal. You're basically asking the Second Circuit to say Hellerstein abused his discretion. That's a high bar. Abuse of discretion. That's the legal standard. It doesn't mean made a mistake. It means acted so unreasonably that no fair-minded judge would have done the same. With 47 pages of detailed reasoning, 8 circuit citations, and Supreme Court doctrine. Good luck proving that. Doesn't mean they won't try. Trump's legal team has shown willingness to pursue every procedural path available. That's their job. Zealous advocacy means exhausting options. But the experts are clear. The specific denial was thorough, and the appellate courts give district judges deference on case management. And that's exactly what this ruling was, case management. Judge telling parties, stop. Useful breakdown so far, hit like. The implication section matters, especially if you've ever wondered how these endless legal battles affect anything beyond the courtroom. Like, if this helps you understand the case, it tells the algorithm this content matters. Why should you care? Real talk, how this affects actual people. Money. If you follow markets, pay attention. Trump Media and Technology Group, the Truth Social parent company, has stock that moves on legal news. Thursday's ruling didn't crash anything, but it adds to the liability picture. $83.3 million, still owed, still enforceable. And after this ruling, fewer procedural barriers between that number and actual collection. Your connection if you hold any media stocks. Legal uncertainty affects valuation. When courts close doors on appeals, uncertainty decreases. Markets react, sometimes immediately, sometimes over weeks. Not financial advice, just what filings suggest about exposure. Precedent. This sets a precedent, and not just for Trump. Next time you or anyone is in federal court, civil case, any kind, and you lose, then appeal, then try to reopen things, judges will cite cases like this. Quick example, say you're in a contract dispute. You lose, you appeal. Appellate court affirms. 6 months later, you find a new argument and file a motion. What Hellerstein's ruling reinforces, if that argument was available earlier, it's not new. You don't get another shot just because you thought of a better framing, not dramatic. That's how civil procedure works now. And this ruling is going in the textbooks. Who's affected? Right now, tens of thousands of civil litigants nationwide operate under the same procedural rules Hellerstein applied. Lawyers representing clients in post-judgment situations already reviewing this ruling. Hits immediately. What nobody wants to say, uncomfortable part. This case is about accountability for defamation, about whether powerful people can call accusers liars without consequence. If you've ever wondered whether courts enforce accountability against wealthy defendants or just let them file forever, this ruling answers that question, at least in this case. Hellerstein said there's a limit. You got your trial, you got your appeal, now it's done. That matters whether you like the outcome or not. Because the same principle protects everyone. Finality isn't just about punishing losers. It's about giving winners something real. Practical, what informed people watching this are doing, following the collection process. When does Carroll actually move to enforce? Watching for any emergency appellate filings. Trump's team has options, even if they're weak. Tracking Truth social stock, if they have any exposure to the position. Question to ask if you have a financial advisor: how does ongoing litigation exposure affect the valuation of any entity connected to the defendant? Knowledge helps. Courts are moving. Money's at stake. And Thursday's ruling removed one of the remaining obstacles. Broader point, federal courts processed about 400,000 civil cases last year. Most ended without national attention, but they all operate under the same rules Hellerstein applied. Thursday, the doctrine that you don't get infinite bites at the apple exists because courts can't function otherwise. If every losing party could refile forever, nothing would ever be final. Thursday reinforced that for everyone. How'd Trump's team respond? Made it worse, honestly. Within hours of the denial, a spokesperson released a statement calling the ruling unsurprising from a court that has shown consistent hostility to the president. Quote, "We will pursue all available appellate remedies. This fight is not over." Reaction: legal commentators noted the statement confirmed an appeal is coming. Carroll's team responded, calling it routine delay tactics with a press release. Roberta Kaplan came back. "The judgment is final. The court has said so. We look forward to the collection process." Then Friday morning, new filing appeared. Trump's legal team filed a notice of intent to appeal Thursday's denial to the Second Circuit. Not the actual appeal, just the notice that one's coming. That filing requires them to submit their appellate brief within 30 days. So we'll know by early March what their actual arguments are. But here's what the notice revealed. They're framing this as a due process issue, not just a procedural one. The notice references constitutional dimensions of the court's foreclosure of further review. Constitutional dimensions, they're escalating the framing. Whether the Second Circuit buys that framing is a different question. But that's the preview of where this goes. Not cooling down, heating up, at least in terms of rhetoric. Whether the rhetoric translates to legal success is what the next few weeks determine. What's still unclear? 1. Will the Second Circuit agree to expedited review? They could. They could also let this sit for months. 2. What happens with collection in the meantime? Carroll's team signaled they're moving forward, but appeals, even weak ones, can complicate enforcement. Coming, the Second Circuit has Trump's notice of appeal as of Friday. Trump's team has until March 8th to file the actual brief. Carroll's team then gets 21 days to respond. Date to watch, Thursday, March 12th. That's when the Second Circuit could schedule oral arguments or could decline to hear them at all and rule on the papers. Should know more by then. Other thing worth watching. Hellerstein's language about summary denial of future similar motions wasn't just for this case. Legal observers are watching whether other judges in high-profile cases start adopting similar preemptive language. If they do, it could represent a shift in how courts manage parties who file aggressively, not sanctionable, but limited judge management, essentially. That's a developing story beyond just this case. Subscribe. When the Second Circuit responds, whether they expedite, whether they schedule arguments, whether they do something unexpected. I'll break it down same way I did today. Hit subscribe, notifications on, stories moving where we are right now. Thursday's denial stands, 47 pages, detailed, citing extensive precedent. Trump's team filed notice of appeal Friday. Actual appellate brief due by March 8th. Carroll's team publicly focused on collection, not further litigation. Hellerstein remains assigned to the case for any future district level issues. Scheduled Sunday, February 8th, 48-hour window for any emergency motions closes. Monday, February 9th, Second Circuit acknowledges appeal receipt. March 8th, Trump's appellate brief deadline. March 29th, Carroll's response deadline. Not public yet whether Carroll's team files any pre-enforcement motions while the appeal pens. Courts sometimes allow collection during week appeals. Sometimes they don't. Clock's running. The $83.3 million doesn't collect itself, and every day of procedural maneuvering is a day it sits uncollected. That's the tension now. Not will Trump win this appeal, almost certainly not on the merits. The real question, how long does the appeal process itself take, and does anything change during that window? Nobody knows yet. That's where we are. Judge Hellerstein, done with procedural recycling. Trump's team appealing anyway. Carroll's team waiting to collect. Surface read. Another denial in a case full of denials, but the language in this ruling is different. More final, more foreclosing, and the notice of appeal, framing this as constitutional, shows Trump's team knows they need to escalate the argument to have any chance. I'll be watching the Second Circuit's docketing. Story's not over, still developing. Appeals take time and courts move at their own pace. But Thursday's ruling narrowed the path, made future attempts harder, put no two bites in writing in a way that binds future proceedings. That's not nothing. Subscribe for the full picture, not just headlines. When the Second Circuit acknowledges the appeal, when briefs get filed, when Carroll's team makes any enforcement moves, I'll break it down. Documents matter, details matter, and in cases like this, the difference between delayed and defeated is in the procedural weeds. I read the filings so you don't have to. When the next one drops, I'll be here. Talk soon.